a plan to protect intellectual property rights of a license. From the movie series 007, one of James Bond's primary missions is to steal critical information from a rival company or nation. Ethan Hunt from the movie Mission Impossible also infiltrates dangerous enemy territory to obtain confidential information. People who uncover a business's core technology and sell it to competing companies are called industrial spies. Businesses that have obtained the world's leading technology are becoming targets of their rival companies, especially in cases of license agreements which allow the transfer of a technology. Many plans are being sought to protect intellectual property rights. License agreements include a confidentiality clause. A confidentiality clause prohibits the licensee from disclosing trade or technological secrets to a third party. It specifically describes compensation for damages in the case that the licensee reveals secrets to a third party. Both parties involved in the agreement thoroughly abide by the confidentiality clause. That is because when a business secret is leaked, serious consequences may occur to both the licensor and the licensee. The oldest and the most common method of technology leakage is to recruit core personnel from companies that have strong capability in the technology sought. In 1994, Ellery Systems was a software company that was partnering with NASA, the telecommunications company AT&T, and the computer company IBM. But two of Ellery Systems' employees, Andrew Wang and Jing Tsui, stole company files and established their own firm, DC Knology. The FBI caught onto them, but due to the lack of laws and statutes at the time, they were freed. Soon thereafter, Ellery Systems went bankrupt. To protect intellectual property rights in license agreements, whether or not a sub-license is permitted needs to be specified. Much attention goes to the royalty provision in license agreements, but in order to protect intellectual property rights, potential leakage to third parties has to be looked at closely. Sub-licensing refers to granting authority to the licensee to license the use of the technology to a third party. It is advantageous for the licensor to stipulate in the contract if sub-licensing is prohibited or partially permitted. Also, since the intellectual property rights of the licensor may be weakened or nullified if the licensee modifies or improves the technology, it should either prohibit modification, prescribe a transfer of the improved technology to the licensor, or set up an exclusive license. If the licensor accepts the license agreement, then the licensee can develop new technologies based on the existing one. Mitsubishi Motors, which signed a license agreement with Hyundai Motor Company, allowed not only the transfer of technology, but also technological modifications. Hyundai Motor Company was able to improve Mitsubishi Motors' engine technology and grow into a global corporation. The license agreement between Hyundai Motor Company and Mitsubishi Motors ended after 26 years in 2008. The agreement remained effective long-term because Mitsubishi Motors' automobile technology was used as the source technology. As such, the permission of technological modifications can catalyze industrial advancements. So, on license agreements, the licensor and the licensee need to discuss and specify each other's rights. Many companies have achieved mutual growth through license agreements and technological cooperation. Licenses allowed legal usage of intellectual property rights of businesses and contributed greatly to industrial development. In the coming years, businesses will continue to build new networks across different fields through license agreements.